State versus Kermode, CR 2023-34. I'll note Ms. Kermode is present in custody in person, represented by Mr. Dean. Mr. Beckwith is here from the County Attorney's Office. We have Mr. Sheffer from the Probation Department appearing remotely. I'll note that we have the victim in the underlying matter, Mr. Kermode, with us as well. Mr. Dean, is your client ready to move forward with this position?
Yes, correct.
Okay, and Ms. Kermode, can you tell me your full true name, ma'am? Mr. Dean, can you turn on the microphone again? Just tap it.
Okay,
there you go.
got
Okay, Ms. Kermode.
Barbara Lee Kermode,
Okay, and Ms. Kermode, what's your date of birth?
64. Okay.
Based on the court's prior finding, it is the judgment of the court that you violated the terms of your probation for the crime of aggravated assault, domestic violence, with the date of violation of January 24th of 2023, a Class 3 felony. I've reviewed the pre-sentence report that was prepared by Mr. Sheffer. Mr. Sheffer is recommending a mitigated term in the Department of Corrections. I'll let the parties know that I am leaning towards a term in the Department of Corrections. I do believe at this point a mitigated term is appropriate. I'll hear from the parties in just a moment. Mr. Sheffer, let me hear from you first. Do you have anything additional beyond what's in your pre-sentence report?
Your Honor, I do. I received a phone call from one of the jail staff 4 days ago and it was reported to probation that the defendant has continued to contact her husband using her tablet while in jail. The jail staff reported that this was some pretty disturbing and concerning contact. And so, Your Honor, given in light of that, probation would ask the court to consider a presumptive sentence in this case, because, Your Honor, this defendant has continued to disregard the orders of the court as well as probation. We've done everything possible to stop that contact with the victim, but it has continued, Judge, and so I just wanted to bring that to light, Judge.
Okay, thank you, Mr. Sheffer. Mr. Beckwith, anything the state would like to add?
The state recommends 2.5 years in Department of Corrections, and also we have a victim here that would like to read something on the record.
Mark, do you have a microphone we can get to Mr.? Oh, good. Mark's ahead of me. Okay, can you tell me your name, sir?
James Kermode.
Okay, and Mr. Kermode, what would you like to tell me?
Judge Wright, you know this case since you've been here, been on it from the beginning, so I don't have to go over what has happened. Barbara has worked to get it through her classes. She has taken domestic violence, anger management, and victims of domestic violence. She has been through counseling just as well as we have. However, our couples counseling did not go well. Every time our counselor would say something that Barbara disagreed with, she would either shut down or walk out of counseling. When Barbara went through her classes as well as her counseling, I feel she just tells them what they want to hear so she can get through the classes. When Barbara and I are together, she is a totally different person. She is constantly angry with me. She constantly blames me for all that has happened. Barbara has begun to curse at me, falsely accuse me, belittle, and threaten me. There are 2 cases that are still pending. One is where she falsely accused me of pointing a weapon at her, which was proven by video to be wrong. And the second case is where she threatened to burn the house down and cause bodily harm to me. That was not the first time she has threatened me. Barbara always says that everything she asks me to do for her, I say no. I've done everything possibly that I can do for Barbara. I've paid all of her bills, provided her with a car, and paid her rent. The only thing I've said no to is she constantly requests that she wants to come home. She wants to live like we did prior to the incident on January 24th, which obviously didn't work very well. Prior to Barbara coming home, I've asked her to change the way she treats me. I've asked her to quit cursing, belittling, falsely accusing, and threatening me. Barbara just keeps telling me that I can't change her and she refuses to change any of her behaviors. Unfortunately, I don't think Barbara has taken her probation seriously. I hope she can realize how serious this case is. Barbara doesn't understand after the incident on January 24th that I have to feel safe in our own home, and with her behaviors that I don't feel safe when she's around. I don't know what further I can do for her or what further probation can do, so I leave that up to you, Judge.
Thank you, sir. Okay, Mr. Dean, I'll hear from you and/or your clients.
Well, Judge, I'd like to focus on what Ms. Kermode admitted to. I know there's a lot of allegations flying around, all of them unproven, none of which have been admitted to. The only thing admitted to is that Ms. Kermode did not report a police contact. That is a violation. I would say, Judge, that if in that case, according to the pre-sentence report and from what I've heard from my conversations with Ms. Kermode, Mrs. Kermode, is that on March 19th, 2025, that she had a medical incident relating to her diabetes. She was transported to Banner Thunderbird Hospital in Phoenix, where she received treatment for blood sugar-related issues. It was referred to as a police motor assist, because when she had problems, she had gone off and was essentially illegally parked in the median while medical personnel responded, waiting for medical personnel to respond. Now, I know a lot of probation officers have very different ideas about what police contact means. Some of them say, look, if it's a civil traffic ticket, no big deal, but I want you to report to me if you've had any contact relating to a criminal incident. Here, there wasn't even a civil citation. There were medical personnel, police officers. Yes, if we're technical about that requirement, then yes, she had contact with the police, but she was in the midst of a diabetic episode for which she was treated shortly thereafter. I think that's a mitigating circumstance. Might not be a defense, but a mitigating circumstances insofar as the degree to which she could conform her actions to the requirements of the law in the way that diabetic episodes can impair someone's cognitive thinking. That's what she's here for the court to consider, is that allegation that she admitted to. And I don't think that that's worth sending her to prison. It seems to me to be rather technical in its nature. She was under duress and cognitive impairment because of the diabetic episode. But it is a violation. It just doesn't seem to me to be the type of violation that would warrant a revocation, and in particular, a sentence of 2.5 years as a consequence of that. I think the case is appropriate for reinstatement. I understand there are some issues I think there's some mental health issues underlying. It's interesting, as I was reading the pre-sentence report, it seemed like there's a lot of things she should be congratulated about. In the evaluation, I'm reading it sounded to me like we're leading up to a probation reinstatement recommendation, but I was surprised that, I guess, the probation officer felt despite all of that progress and all of those accomplishments, she should be revoked. That recommendation just didn't seem to jive with what I was reading in the pre-sentence report, predisposition report. So I would ask the court to consider a reinstatement as what's in the interest of justice, but if for some reason, Judge, you do feel it's appropriate to revoke her, then certainly I would recommend that and request that you impose no more than the mitigated term in this case.
Would your client like to be heard today?
I believe so.
Yes,
Okay,
sir.
go ahead, ma'am.
I have worked hard and diligent to meet the requirements. And I've gone to extra classes. I'm doing classes at the jail. I'm working on it. Mr. Kermode doesn't seem to feel that any place that I've been to, and I've been to maybe 9 or 10, that haven't worked on us. It wasn't about us. So we made a deal that if we did, couples counseling, that I would be able to come home. And then he changed it on me. It's like, he doesn't want to do it that way. He came up with these, I can't accuse, I can't belittle. I can't do any of this other stuff that he's done to me as well. He's not innocent in all of this. But everything that I've done, he has said that it doesn't meet his standards. So it's very frustrating and maddening to be told that we make a deal and he follows out of it, that he can change it on a whim. That's not something a husband and wife does. He's not innocent in all of this. He had PTSD for 9 years and he took it out on me at home. I wanted to leave and he said if I left I'd get nothing. He's now threatening me to talk to you about giving him the house and all our assets, that I'm not entitled to anything. It's my house too. It's my stuff too. I worked for it too. And he's gonna take it all away. He's gonna talk to you about taking everything away. Wouldn't you be mad? Wouldn't you be upset? I'm sorry this all happened, and I've apologized 100,000 times, and I've worked hard, and everything I've done is not good enough, according to him. I've been in Tucson. I wasn't supposed to be. I found out that I needed to move, that I needed to be up in Gila County. I had no probation support down there at all. I had to always come up here for UAs. Called Scott. I've had phone problems. I had my phone replaced twice. I did the art meetings, and for whatever reason, the art meetings didn't come through on my phone. It was always changed, so Tyler would have to resend the link for me to get onto the art meetings. And that happened quite a few times. I've done everything I've been told and extra. I've learned to be humble. I've learned that what I did was wrong. But when you're constantly pushed from the other side that you're wrong, that you haven't done enough, where it took two of us to get to this point, but I'm the one doing all the work. It took two. I've been in contact with him because he got hurt again at home. This is the third time he's been hurt. I wasn't there. I don't want to get blamed for it. I want my marriage to work. I want him to be healthy. This last time the dog pulled his arm out of the socket and now he has to have surgery. Nobody to take him, nobody to take care of him, nobody to take care of our house, nobody to take care of our animals. I wish you would put me back on probation and lift the order of not being on the property. Change in behavior takes two, but when you're constantly knocked down and belittled, it's hard. I'm doing classes in jail. The certificates are on there. I've been working on it. It just doesn't meet his standards. I've asked to have a third person involved in our conversation, and he won't do it. He holds everything. And I want us to work it out. I want to be off of probation. I've worked so hard for all of that. Extra classes. I have notes, they're not here, but he has the binders. He has my letters of recommendations from people who know me that can prove that I've worked really hard on everything. I stayed in a boarding house with a pastor's family. I have a letter somewhere. He has them. I had him in the car the day I had the accident, and I asked him not to take the stuff out because I would need him here. And he took them all out, and now he can't find them. I've worked hard. I know what I've done is wrong. Yeah? I'm okay.
Thank you, Mr. Dean, Ms. Kermode. Okay. The court has considered the following aggravators and mitigators. Aggravators, as originally alleged, the infliction of serious physical injury, victim harm, and the use of a weapon. The court will find an additional aggravator of repeated unwillingness to follow probation directives. far as mitigators, I'll find her admission and her mental and physical health as mitigators. Considering all of those, the court finds that probation is no longer appropriate. The court does find that a mitigated term is appropriate. It is the judgment and sentence of the court that the defendant's probation is revoked. She'll be sentenced to a mitigated term of 3 years in the Department of Corrections. That sentence will date from today's date. I'll find that she has 98 days credit. I'll order that she serve a term of community supervision pursuant to statute. I'll order that all outstanding fines and fees be reduced to a criminal restitution lien and entered into the tax intercept program upon her absolute discharge from the Department of Corrections. Order that the Department of Corrections notify the clerk of court of the defendant's final release type and date. You have the right to petition for post-conviction relief from the orders of this court and to have a lawyer represent you. If you cannot afford a lawyer, one would be appointed to you. If you cannot afford copies of the necessary records and transcripts, they can also be provided to you at no cost. If you want to petition for post-conviction relief, you'll need to do so within 90 days of today's date, or you'll lose the right to seek that review. I'm going to have you come up, sign for your review rights, and provide fingerprints to us. Mr. Dean, anything else in this matter?
Nothing further, thank you, Judge.
Mr. Beckwith?
No, Your Honor.
Ma'am, if you come up, we'll have you come up here to Mark. He'll help you with the fingerprints.